Are we ready?
Is it being recorded?
They can hear me through a cookie. That means
Too quietly. You picked up a respiratory bug.
Wait, Mr. Week. Sorry. It's not, it's more of a.
I think we're good? Yeah. Okay, so I'll start recording here. No.
This meeting is being recorded.
all right. This meeting of the Norwich Select Board is convened at 6:39 p.m. on the 16th of April, 2026. I am Pima Griggs, Chair of the Norwich Select Board. I'm joined by Brendan Klassen, Vice Chair, Mary Layton, Matt Sweat, and Rob Gear on the other side of the table. Town Manager Brendan Duffy is with us, doing his best to keep us from running amok, running the Zoom session. Notes will be taken by Lister and emergency replacement note taker Pam Smith. Thank you. And Ivan from Junction Arts and Media is enabling our digital communications and recording. Thank you for attending this special meeting of the Select Board, which has general supervision of the town of Norwich. We appreciate the valuable contributions of our town employees, elected and appointed officials, and the myriad volunteers that make our town what it is. We endeavor to be respectful of everyone while keeping what is best for Norwich as our North Star. If the chair recognizes you during our meeting, please try to keep your presentation to a maximum of 3 minutes. Vice Chair Klassen has been invited to remind you when your allotted time is up. We have a gavel for show. Thank you. I'd like to recognize that in the public we have Vermont Senator John Carroll, former Select Board member Priscilla Vincent, and Lister Cheryl Lindbergh, as well as a note taker Pam Smith. All right. Agenda, item 1. Any discussion? Any discussion on the Select Board?
It's good to me.
Public? We have one raised hand. Priscilla, would you like to come up and treat yourself to a cookie? And
Thank you, Mr. Chair. Priscilla Vincent. I am mildly astonished, having been on the board when the alleged violations took place, and they concern improper use of executive session. I'm mildly astonished that there is even a mention of a proposed executive session on this agenda.
noted.
Was that a public comment? Just asking.
I believe it was a public comment
Okay, were we going to approve our agenda?
regarding the agenda. So,
Is that when we take them?
well, it was a comment on the agenda.
But it
So
was not by a member of our board.
that's correct.
Okay, just asking. I appreciate the comment. Just wondering if it came, in the proper time.
Perhaps not. Well, whatever you like to.
In the context of
Just how we organize our meetings. Right,
Generally, the agenda is looked at and voted on by.
yeah, by us,
Public comment.
right.
It's unusual to have anybody who wanted to comment on the agenda. But because the comment was about the agenda and the thing that was on it.
Right, but that could have been made during public comments.
item 3, you're saying,
However, by that time.
but it's on the agenda.
Oh my God, the chicken and the egg.
Well, it is, yeah. So
So every time we have an agenda to approve now, we'll have comments on it. That's what you're saying? I'm just saying, is this a good precedent to set?
It's rare.
I mean, we don't have to debate it now. I just think it's unusual.
it is unusual.
And I
I agree.
kind of don't appreciate it either. Okay? But
Okay.
you like it moved?
Would you like a move?
I move to approve the agenda as presented.
I will second that.
Okay. Any further comments? None? Let's vote. Klassen,
Yay.
Clayton,
Yes.
Shear,
Yes.
Sweat,
Yes.
and Briggs is a yes. All right, moving on to number 2, Chair's report. I am going to, in the interest of time, delay my Chair's report until our next regular meeting next Wednesday evening. Which brings us to item number 3, public comments for items not on the agenda. Discussion. Are there public comments? I see 2 hands. Please.
Well, it is on, Priscilla Vincent, it is on the agenda, but this is public comment time. As I said, I was on the board at the time of the alleged violations, and I'm very surprised that stuff was provided to Mr. Katucki with redactions, and I don't understand why they're redactions, and I hope that his request that things be put out in the public without the redactions be honored.
Thank you, Priscilla. Voting time.
Yes.
Cheryl Lindbergh. I would just like to state that there have been agenda-related comments made prior to the agenda being approved at prior select board meetings. And they have been public comments because there may be, as I did once, come forward asking if you could adjust the agenda. So in order to impact an agenda, a comment needs to occur prior to the approval so so this has happened. It is not unprecedented. And so I would just like to remind all the chairs that have served that that's the case.
Thank you.
Thank you, Sean.
Noted. All right.
Yeah. Might it not be appropriate to move the acceptance of the agenda and then have discussion? Is the normal method of dealing with agenda items.
Yes, that would be a better strategy.
Yeah.
We'll do that in the future.
Okay.
Move and discussion, then yes, that would be the.
That's kind of normal.
Are there any other public comments? Anybody on screen? Seeing none, I think we can move on to number 4. Consider response to alleged open meeting law violations by Christopher Katucki. I'd like to introduce this. I was saying this special meeting was called to attend to a written notice of alleged violations of Vermont's open meeting law by the Norwich Selectboard. As prescribed in the document included in the meeting packet, the notice was sent by Norwich resident Chris Katucki, and we are required by law to respond in a timely manner. Mr. Katucki has agreed by email to extend the deadline for final response to next Wednesday, April 22nd, in order to include our final response in the regular meeting. Our meeting this evening is intended to review and discuss the notice to establish what action, if any, we intend to take on April 22nd. I think it's important to note that it's the responsibility of the select board to decide how to act on this. Our town manager has been engaged with town council, but it's not the TM's responsibility to decide what action to take. We have to tell them ourselves. Town council has been invited to attend our meeting. We may call on them for advice. If an executive session is called for, I will ask council to describe in detail what the matter before us is and why they recommend entering executive session. We have 5 alleged specific violations to review and 6 specific requested cures. I suggest we discuss all of the violations before considering how to respond to the requested cures.
Agreed.
All right. I think discussion before any motion is called for here. A chance for us to discuss what we read, what we'd like to do, Correct, everybody's read the,
Mhm.
all right, so,
If I may, Chair Gibbs, just to lay out what the statute says, the town has 10 days, but I didn't know Mr. Katucki had granted an extension to Wednesday to respond, but the statute provides that once the public body receives the violation, it has 10 days to publicly address it and whether and either admit or deny. And then after that, has 14 days for any admission to provide a cure. So we don't have to do it all at once, is all I'm saying.
could you, just identify yourself for the record, please?
Oh, I'm sorry, Chair Gibbs. My name is Bariah Smith. I'm an attorney for the town of Norwich.
Thank you. All right, so item 1, posted agenda, item described, item 6, our district tax exemption agreement. We entered into executive session with a motion referencing potential litigation. We didn't provide enough detail going into the meeting. Is this something anybody would like to comment on? I don't feel like I should be telling you what to do or how to think.
I defer to maybe the select board members who were on the board at that time, and I'll proceed maybe after that.
All right. The issue isn't that we went into. Yes, Mary.
Okay. I wouldn't admit or deny anything, but just as a point of trying to do a better job for the town or the select board to meet the legal requirements, it would help my thinking to know, for instance, how specific is a specific finding? How much detail is required? Right? And what is our understanding of the context of any issue that might have some legal ramifications? And I don't think that they're necessarily always clear. So that's, and I think possibly had quite a hand in framing some of these agendas and thinking about what amount of information would be appropriate. But I don't find that task easy at all. Like perhaps, I don't know, maybe we rely a bit too much on our support from legal counsel, but on the other hand, I think the statute has terms like specific finding, which may not be so clear to a layperson. So I will just say that.
Agreed.
About all of these.
So I think all of us read these complaints, and it's pretty clear, like nobody's calling us bad people or that we have ill intent or but that we can do better. And so this is a cautionary sort of warning that we should do better. But yes.
I agree with that. I don't think anyone here has sort of intentions to do something that would hurt the town of Norwich. I'm just saying that sometimes it's really hard to know how to frame the how to set up the agenda so it's appropriate, how to set up the motions, whether or not there might be possible litigation. I think sometimes there is a question, and perhaps we've gone too much in the direction of relying on counsel. If, maybe there's a way to just, the question in my mind, would we not be here if we just discussed everything about these agenda items in public? That's a question of mine. Like, what if you just let it rip wide open? Would that be exposing the town to later legal issues. So it's not always been clear to me. And you guys don't have the experience of doing it. So I'll just say, it's not so easy. And would appreciate, maybe there's a way, I think Mr. Katucki was saying, one of his, besides the allegations, was saying, well, maybe the support system for creating the motions needs to be a little more guidance. Maybe there needs to be more of a test for whether an agenda item is going to be appropriate or not. We might need a little support system to do this correctly, to do our best for the town.
No,
That's what I'm saying.
yeah.
But that's not the job of what we're doing tonight, because we have all allegations, and I believe we have to say whether we admit that we, messed up, or we say, no, we think we did a good job.
Yeah.
And to me, it's not clear. And that is why I would appreciate being able to go into executive session, to work with our counsel, to just understand, did we or did we not provide enough detail? Did we or did we not frame our agendas properly? So I would appreciate that opportunity. So, and I'm done for now. Maybe Matt would like to speak, I don't know.
Matt.
I had some, I was hoping to kind of go through this in a linear fashion and address all the specific stuff in line. It seems like that number one, his specific violations alleged, number one seemed to be just talking about word choice, proposed versus possible as the definition of the agenda item. And so, clearly when you read that the statute, it does say proposed executive session should be used. We didn't use that. So my question, I think there are a lot of questions that we can pose to council outside of executive session. And this would be one of them, which is that going forward, like, did we do something wrong? And going forward, what's the best practice? That's one of the questions. That's the question I would have to ask for, violation number one. I could take a guess at the answers to that, but I'm not the lawyer.
Yeah. Okay. Mary.
I would like to add to that. I think it is more than just the word choice of proposed, because the next part is referencing, I guess, 1 VSA 312D3, that a meeting agenda contains sufficient detail concerning the specific matters. So
Right.
That's what I was getting at. So it's not just the, substituting proposed for possible, I don't think.
Well, I was just going through one at a time, like one.
This one?
Yeah. So number one.
That paragraph, okay,
Yeah.
right?
So So number one seemed to just talk about the
Yes, I
verbiage.
agree with that.
So I wanted
Okay,
to kind of
sure.
just check that off,
Good.
maybe
Yeah.
get that answered and
All
move on
right.
to the next one. Yeah, and I would agree that number two is about verbiage too, but then if you go on to 3 and 4, it's more about how we framed, why are we leaving?
Okay, you're going paragraph by paragraph, so this is 2, this is 3.
Oh, okay.
Now we're number 2, right?
Well,
All right, so maybe just the question about proposed versus possible.
okay, because that's,
Are we all looking at this document?
Yeah.
In number one.
Okay, good. Just making sure. So number 1, moving back, is there general agreement that we feel with different language, we might not be trouble here? Not that we're in trouble, but that had we used different language, this would have been satisfied.
just for that specific question about whether to
Yes.
use, I think that is something that we could move forward with, I guess they call it curing. That's a very simple thing to do.
Mhm.
I think we even tried to do that in our revised draft agenda today. So yes, I think that's That's very clear. It's easy for us to do. Yeah. So I would agree with that one.
I was thinking a little bit, the choice of words, I think, in many respects, is really on us and our intentions for what it would be. So a possible executive session is a bit more imprecise and undetermined, whereas proposed is something I guess the select board is proposing, and here's why we're proposing.
Or intention behind that word.
Or intention. And maybe something, look, I only peripherally know about this because I wasn't on the select board at the time, but I've tried to do as much backfilling as I can. My understanding is that there were a small subset of properties that had been historically or grandfathered into some type of property tax exemption that belonged to the fire district. And the select board was going to review the history or the path forward.
So we're not actually talking about the case here.
No,
We're
but we need
talking
to
about the process.
but we need to disclose enough about the case to inform the public without disclosing everything.
Yes.
That's the trick.
You don't say there are 7 properties on the town line with Thetford, 2 encroach on this, 2 are by the river, 2 are privately owned, 3 are publicly owned, and here's the problem. You don't say that.
Why not?
It's too much. That's
How is that too much?
confidential, right? I just made it up.
Okay. So,
I can't
yeah, but
encroach on
what we're being asked for is language that clearly identifies why we'd be going into executive session.
but sufficient detail concerning the specific matters to be discussed.
Yeah.
Which is a property tax exemption for a select number of fire district properties.
Mm-hmm.
I think what Mr. Katucki is saying is fire tax exemption agreement is too brief, too pithy, and uninformed.
Yeah.
On the agenda,
Right?
as listed on the agenda.
Yeah, as it is
And how would you phrase it?
well, I don't know enough about the case to frame it with more detail, but not too much. But maybe that's what
Is that a spot where we could use some guidance from council or not?
I'd like to go through all of the points before we move to ask advice on any of them.
Well, I mean, we could, well, okay.
But we have a couple of hands up, one from the public and one from our town manager. I'd like to recognize the public here, if I may. Yes.
Can I speak from here or should I come to the table?
Well, a table would be nice.
The microphone will probably be.
Please join.
Better to come up.
Thank you.
As you're on
We
the
insist.
tape that way. Well, no, it's on the tape that way.
Thank you. I just wanted to provide just some factual information of what was actually in the warning for the meeting, because that's what Mr. Katucki's concern is in number 1.
Yes.
It is in the warning. He's concerned about what was in the warning with regard to number 6. Now, I have no way of knowing what was actually the topic of number 6. But all that the warning says is fire district tax exemption agreement. That's all it says, those 4 words. So I would interpret his challenge, and believe me, I'm not advocating for one side or another here. I would simply interpret his challenge here to be saying that more detail in a warning would be appropriate.
It's an agenda, but yes.
In the,
Right.
the warning, which I think normally has, I'm sorry, in the agenda.
Yeah.
Pardon. Thank you. He also raises a question about possible versus probable, but that's a separate question, I think.
Yeah.
And then with regard to number 8, again, a fairly complicated discussion. I note that it took an hour for you to conduct your executive session, so there was a lot of material there. And you devote 4 words to it: draft, audit, process, question. So I think you're on the right track. I hear you when you say we want to do it better. I would just point out to you that by the end of next meeting, you have to be very specific about how you will do it better in order to comply with the statute.
If we admit that it needs to be cured.
If you wish to improve it, and I think I hear you saying, I wish to do it better. And if you are willing to concur that it was insufficient and needs to be cured, then you have until the end of your meeting on the 22nd to do that in I think, fairly specific terms. That's all I just wanted to share with you. Thank you.
Our town manager, would you like to go after the public or before the public?
My only comment was there was a slight conversation going on here. I don't see the stop, so I could go to the meeting.
Okay, thank you. Noted. Nancy, Carol. Oh, no, that's the cursor. Do we have any hands up? No.
It's the cursor.
Yeah. I'm always, yeah.
Sorry, Nancy.
Yeah, sorry.
All right.
So it sounds like the general agreement on 1 and 2 is that we could do better. We understand how we could do better. And we can agree to do better. Is that a fair assessment of
I think
no, that's not saying we've done badly. It's just we can do better. And
so I think the potential here that people may be getting disconcerted by this lack of detail. Because if you look at it at face value and you don't know anything about fire district tax exemption agreement, so one person may say, maybe they live in the fire district, maybe they don't. Who's getting a cut? Who's getting a deal? Am I missing out? Why am I missing out? And who's getting the favorable treatment? This is a potential conclusion that a member of the town could possibly have with so little detail.
Sure.
So hence my reference to stipulating a very small select number of properties, if indeed I'm correct. You folks were there, I don't know how many properties are involved, what area, what nature they were. There's an area 5, right, or something?
There's parcel 5.
Parcel 5, yeah.
I'm forgetting how much of this was in the packet.
Yeah.
Something in the packet that described what we were talking about.
So the title should reflect exactly what's in the packet in a moment. Obviously.
Well,
to the extent that you can write.
I mean, usually the title represents what we're going to be talking about. And then when you read the packet, there's supporting materials for the headline of what we're going to be talking about.
Yeah.
And for executive session, more rather than less seems to be the order of the day here, at least for titles in agendas. I think that's what we're seeing, right?
Yeah.
We're sort of experiencing that.
I think so.
Yeah.
Okay.
I'm just trying to view it from someone else's perspective here, rather than me having some inside knowledge, albeit minimal. What would someone in the town who knows nothing about this, what would disconcert them about this? And I think that's what Chris Katucki may be getting at in the longer term here.
Absolutely. That seems pretty clear. Are we on to item 3, or did we include item 3 in that discussion? I'm a little confused now.
I don't think we did.
3 is the cure being asked for is considerably different, much higher level than admitting we used the wrong verbiage.
Disclose the nature of the legal dispute.
Gosh.
Is there a reason to not disclose the nature of legal dispute? It's well, I'm asking among the 5 of us. We know the parties involved. It really is a question. It's not a. It's a procedural question more than, it's not some horrible legal fight. but maybe we could ask for counsel on that. Okay. Before we do that, however, let's see what else we have. Number 4, public exclamation motion enter executive session during discussion of agenda did not adequately indicate the nature of the business. So that is similar to number 2, I guess.
Yeah.
The quorum email exchange. But this was this is noting that we had communications that perhaps went beyond what we ought to have had via email and texting and so on, correct?
Mhm.
Yeah.
That's the allegation.
And
Meaning discussion of select board business outside the public.
town business, look for business. Yeah. So
You're talking about number 5. The
Yeah.
email exchange appears to exceed the limit exception in 1. So that we were talking about, and we were discussing whether or not to go into executive or to put executive session on the agenda
As an option.
as an option.
as an option.
And I would love to have, I don't know, legal opinion on if, how much of a discussion we can have.
I would
If we're talking
appreciate that
about
too.
agenda items, we have to, is it literally that we can say, yes, I support this item, or no, yes, I support going into executive session, or no, I don't support it? Or can you know, it's not always as, I don't know, discussions aren't always as binary. And in order to make a decision, sometimes it can be, I support it if this is true. I don't support it if you know, X, Y, and Z.
Yeah.
Is that an okay discussion? Because we're discussing how to form the agenda. Is that an okay discussion to have on an email thread? Or does it have to be as black and white binary, yes or no, and that's it? I would love that, you know, I'd love counsel to advise us on that.
And perhaps further to that, if you have a non-binary conversation with the chair, is that allowable as opposed to a non-binary conversation with the entire board for agenda setting or information?
Right.
So, for example, I might have written back, theoretically, that I did not want something on an agenda, and here are the reasons why. And I shouldn't have written the reasons why, apparently. I'm told. I should have just written back, no, I don't want it on the agenda. That's fine. Otherwise, it's a conversation.
And it's the chairman's prerogative to yay or nay that.
The chair can propose something for the agenda, can put something in the agenda, and they send it out to everyone. And if 3 people write back, hey, I don't want that on the agenda, it comes off the agenda. They can also write, say, somebody has proposed that this go on the agenda, or one of you could write, I'd like to see this on the agenda. And if 2 other people agree, it is meant to go on the agenda. But
Good.
It's just about yes and no. It's not about your reasoning. That is a conversation, I believe. So we have another hand up from a wise man. You may, please.
Thank you. Thank you. I'm John Carroll. I just was looking for the length. I'm dividing this up in my head anyway, that number 1 and 2 are about the warning and the agenda. And number 3 and 4 are about how you talk about going into executive session and how you describe what you're going to do in executive session. And number 5 is about email conversations. And since I know nothing about the subject and the nature of the conversations, not very little of that's been revealed, much has been redacted. I don't think I can offer you anything useful there other than to remind you that communications outside the meeting among you all and without the open meeting law applying are permitted only for the purposes of establishing an agenda. Only. Very clear in statute. And by the way, you keep referring to it turning to an attorney. I would just remind you what I lectured you about a month ago. You can read this stuff yourself and you can understand it. The Supreme Court has ruled over and over that the plain language of the statute is 99% of what it's about. And this ain't rocket science. And so I'm looking right at the statute here, and it says, a meeting agenda shall contain, and I grant you this is not very specific, shall contain sufficient details concerning the specific matters to be discussed by the public body. That's true of all meeting agendas. Every item on the agenda, whether it's going to be an executive session or not, is supposed to meet that test. Now, what's meant by sufficient details, I think, is tricky.
Yeah.
But if you start from the premise that democracy dies in darkness, that Vermont has a 200-year history of devotion to openness and governance, and that the predominant goal of everything you do is to be open about it, then that would cause you, by virtue of your values or your allegiance to that value of openness, to err on the side of being open and detailed. So maybe that's a way to sort of say, well, where should we land on this? And I think the answer is, because the statute could be read in different ways, all I'm advocating to you is that your attorney and you do not have the same interests. You have taken an oath of openness and duty to the town. The attorney has a different set of very important ethical obligations.
To the state.
Pardon me?
We gave an oath to the Constitution,
Precisely.
not to the town.
Right, pardon me. Yes, your oath is to the state and what it expects of its municipalities. And we know that the state is very dedicated to openness. So whenever, if there's a doubt or a question, err on the side of saying too much. It's to the point where people get saying, okay, I've heard enough. We just get on with it. To speak, I think the same rule applies to the questions 3 and 4, which is what do you say in the board meeting when you wish to go into executive session. Yeah. And you remember on the 25th, when I spoke to you, 25th of last month, we talked about that. And then I sent you, I felt I let you down a little bit there because I didn't give you any specifics about what a better explanation would be for going into the executive sessions that you did go into. And so I sent you a kind of an example of that. This is what would have fulfilled, perhaps even more than fulfilled, but revealed nothing private. What the heck this is all about? What are you going to talk about for an hour? And it gave that I think might serve for you, if not as a template, at least as an example of the kind of straining toward openness as opposed towards straining toward privacy that I think we're all asking you to consider. Can I answer any questions, or is that, I hope that's useful.
No, John, very useful.
Thank you. Thank you.
It supports your emails, which are very valued. And thank you.
Now, public comments, yes.
So it seems like to focus on the agenda setting discussions that sometimes we need to have to figure out whether we want to have something on the agenda. I guess whether or not it's a executive session or not. Other than just proposing a line item that's, I would like to talk about this. Is everybody in favor of that or not? That we might want to have our agenda setting as, as part of a regular, the end of the meeting. Maybe we talk about agenda for the next meeting, because then it can be out front in person.
Yeah.
Or at least
At the beginning of the meeting.
at least important things for like the next meeting that would be on next
2
meeting.
weeks from now, this will be. Okay.
Yeah, because that then makes it like, I haven't found a very satisfying answer yet to the email thread about discussing what can be on the agenda and where the limits are unless it truly is yes or no. And that seems very confining to like deciding anything. So maybe that's one way to do it, or at least to do it for like things that might be that we need to discuss. You know, there are probably like 50%, 75% are kind of no-brainer items that have to be on there. There's not really any discussion about it. The other ones are the more important ones, I think, that are dealing with like moving us forward as a town.
Yeah. Okay. Yeah. Knowing what's going to be on an agenda 2 weeks in advance. Just, we could obviously add things.
Yeah. And it doesn't even have to be. You could say, you know, I think we should talk about the X, Y, and Z. This is what I think. What do you all think? Yes, we think it's valuable. Let's find a time to put it in. It doesn't have to be the next meeting. But,
Yeah.
but that way it gets in the parking lot and we know that everybody's in favor of putting it on.
We did that last week with, for example, I think the Public Works. We said, oh, maybe we should put this on a future agenda. It seems to me that we have to determine whether somebody goes in as a proposed, you know, if you are going to go into executive session, be asked to either write that it's proposed or it's, what was the other term? Possible.
Yeah.
And
I
proposed, it could be more definite perhaps than possible. This might be a good moment to say that in meetings with the town manager, I've suggested that if there is a proposed or possible executive session, we invite council into the public meeting for questions before we go into the session, to talk about it as much as we feel comfortable, and then ask council to say why we're going to executive session, so that we're not translating, or our town managers have to translate what the lawyer would have said in this instance in order for us to go into. Let the legal people say the legal stuff so that we can have our meeting. Does that make sense? I mean, they're here already.
As a pre-meeting.
Yeah, so if it may be that in the public discussion, you discover you don't have to go into an executive session. But at a certain point, you know, depending on how uncomfortable we make our council, we can decide, right? But we do it in public, and then the language can follow.
Yeah, and then I think the public they receive the impression that we've done our diligence, reached out to council, and done our best to avoid obfuscation, secrecy, whatever else we may be accused of doing. We've made our best good faith effort in a public forum with council.
Yes,
this will have to help the situation, I think.
Right. Anyway, that was my suggestion.
That's a good one.
I don't think it takes any longer because you're asking the questions in here that we would have asked outside of here. It means the public can engage longer. We're out of the room less time, and maybe we don't have to do it at all. Go into executive session. So that was my suggestion. I think our town manager thought that seemed reasonable,
and that's for the thorny issues.
Well, it deals with some of them anyway.
Executive session issues.
Yeah, I mean,
not like the run-of-the-mill, warrants and everything else, right?
Yeah.
Okay.
So
it would be only when we go into executive session.
Yeah.
And probably for ones that may be a bit ambiguous. Like if we're going into executive session for a contract negotiation.
Yeah.
That seems like fairly straightforward.
Yeah.
Or for a lawsuit against the town. That seems fairly straightforward.
Yeah.
But even there, it doesn't seem to me to hurt to have counsel facing the public and speaking with us, so everybody can see what's happening, and it becomes very clear we can't say any more without.
Sure. Yeah, definitely worth a try.
But to John's point, and I think this is a really good one, our deliverables and who we answer to are different to the lawyers.
Yeah.
So we, I think, should be very careful to push the lawyers as much as we can for max disclosure or appropriate disclosure, and only pull back when we're advised to our satisfaction, and this would be injurious to the town, injurious to this property holder, whatever the case may be.
Yeah, we get to judge that. It's true.
We make the call,
yeah,
and we pull it back if legal counsel advise that. Or if they say, hey, it's okay, it's, I'm not comfortable with it, but if you guys insist, then, it's your call. Maybe something like that. I don't know. It's never going to be black and white, but
maybe.
And if the public see this,
Yeah.
I think this will go a long way.
Yeah, I agree. The other thing that I suggested was if we know we're going to have council invited to a meeting, we start an hour early and do that work. I have to find out if people can make it, but that was a proposal. So do that work at the start of the meeting, before the regular meeting, or we take a break before the regular meeting continues. But that way we don't get in the middle of a meeting, disappear for 45 minutes, have everybody sitting around eating all our cookies, getting bored.
May I suggest half an hour?
We just do it early.
I'm confused about what you're saying as far as that, doing it before the meeting. The meeting is a public session.
I'm saying start the meeting an hour earlier and do that part of the meeting first. Still a public meeting, still the same meeting.
Right.
But we just start a little earlier. Because when we have these sessions, we tend to go late. I think. Yes,
So
Mary.
would this be with council present for that
Yes.
hour?
Yes. And
Okay,
it's
well-
earlier for them.
Right, so, tonight we're having a meeting, we started a little after 6:30. Council's been sitting here for an hour, which, right, costs the town money.
Yeah.
So, I don't know if we've really gotten to the bottom of going through all the items and making decisions on them. Meanwhile, we have council and we are not, perhaps some of us would like to make a decision based on some advice from council. So would you recommend, I just don't know how to parse this at all.
Well,
I really don't.
council is,
It's like, do we ask a general question of council? Like, for instance, let's say we're framing an agenda item. What is the proper amount of definition? What's the, and how much detail do we have to provide? I mean, maybe that's something that, we could ask for. But as far as the specifics of any of these, I'm not sure. So I'd appreciate the advice. And we've just been going around and around, kind of deciding what to do, but not really.
okay, well, we haven't gotten that. I mean, we're making our way through.
Right.
And council has had the benefit of listening to us discuss
Well,
this.
that's
and understand where our concerns are.
Okay.
So that now when we, I get that you're feeling a little impatient, but we are now through number 5, I believe. We talked about all the points. And now we would like to answer 1 through 6 at the end, right? Based on our
I
discussion.
think he might have some input.
Yeah, so let's hear from our council, please.
Hi, I just wanted to address kind of what you were talking about, and what the senator was talking about. I understand that my interest is that of the town. I don't quite see how, like, your interest, the town's interest is my duty bound. You're the client. The town, well, no, the town is the client, and I am like dutifully to do what's best for the town and advocate for what's best for the town and advise in the town's interest. And I also swear an oath to the U.S. Constitution and to uphold the laws of the state of Vermont. So I don't see how our interests diverge. And as far as the talking with council about going into executive session beforehand, I think it's going to be more difficult than you know, because once you start talking about, well, the questions will be, well, what are we going to discuss? What is this a matter? And then like questions, answering questions, legal questions, and providing advice in open session has come back to bite the town in litigation before, citing, well, council said this in the open session. I just think there are some practicalities that may arise. But you guys are driving this ship. I'm just here to advise. One of the things that could come up is you don't like my advice. You don't agree with my advice. Now, and if we had that, if I gave you my advice in open session, now everybody knows that you're going against council's advice, and they could use that as a bludgeon against you as well. So I just some things to think about. You guys are driving this ship, but I just wanted to provide some practical issues that might arise. That's all.
Thanks. So, I'd like to respond, I think, a little bit. I don't think any of us would intend to put you on the spot in the way that you're describing and ask for legal advice to be given necessarily in the open. But there are many questions that you might be able to respond to that don't amount to legal advice, procedural, informational.
Like I just did earlier this week. Yeah, like I did earlier. Yeah.
Yeah.
Right.
Yeah. And when you do that in public, it saves them the time of waiting while we hear that just for ourselves. So we can go in with you and do the business that we need to do, but the rest of it can be open. Do you have any objection to being the voice that says why we're going into session? That seems to me to be your...
The problem there is sometimes you guys will know better than me the answer to that question. Sometimes we go into executive session to get the facts of what the town did or didn't do, what's going on. Giving why you're going into executive session.
Okay.
Stating why you're going into executive session. It's basically the motion says provide the nature. The motion to go into executive session says provide the nature of the business of the executive session, which is essentially referencing the exemptions that allow for executive session and say, well, we're going in to discuss the rights and obligations under a contract. That would provide the nature of the business you're going in to discuss, that kind of thing. So, I mean, if you wanted me to do that, we could. If you directed me to do that, I would. And I'd do my best to fulfill that.
Okay, yeah, my experience, I guess, has been that you know the case.
Yeah,
better than I do.
It's not always a legal, like litigation stuff. Like but yeah, I understand. Yep.
Okay. Okay. Well, we have our hand raised. A familiar hand. Yes.
Thank you, Mr. Chairman. Two things. You mentioned doing it earlier in the evening, presumably for the convenience of the attorney.
And all of us and the public.
Well, I guess the question gets to be, is it more convenient for the public for your meetings to start at 5:30, not 6:30? I don't know the answer to that question, but it seems to me that the public's convenience takes precedence over that of a hired attorney. Number two, I would just observe that you are the ones who've taken the oath to serve the town. You are the ones who've been chosen by the townspeople to govern them and this town. It seems to me that on any important decision, including one about whether or not you should have a secret conversation or not, you are the ones who should be making that decision and taking responsibility for making that decision, and not subcontracting responsibility to an attorney. He has taken no oath to serve the people of this town. He's taken many important oaths to the Constitution and many other important things, the Supreme Court of Vermont, and all of those things. You've taken
a duty to the client, duty and loyalty to the client.
Yes, and to the client. Yep, you certainly have the client's interest. There's no questioning that. But the client knows has an obligation to the people of this town for responsible decisions. And so by asking the attorney to give the reason for going into executive session, you're essentially subcontracting that work to somebody else.
Yes.
Okay.
We may not see it the same way, but that would be the view of at least one townsperson.
Thank you, John.
To be honest, I think that reading the list of things that are appropriate to go into executive session, if it's not obvious to us why we should be able to go into executive session, then maybe we shouldn't go into it. You know, it should be really like when we make the decision to go into executive session, it should be clear enough to us that we can articulate why, and that would be. I think that would work.
In the past, we've been advised that council has advised that we go into executive session.
Mhm.
Advised to.
So that's where the complication is for me. Okay, they've advised us to go, we don't want to go into executive session. Why? I don't know why.
Sure.
I mean, I could come up with the reasons why, but they've advised us to do this. Why have they advised us to do this isn't always clear. And I think it's one of the reasons it's led to maybe not as full and precise language as other people would like. Because we're not quite sure when we're putting it into the agenda. It's not coming from us. So
If it comes from.
well, it may come from some legal concern. Or
It might be union negotiations where you don't want to, but I think that's probably more cut and dry.
Right.
Yeah,
yeah.
cut and dry
Contract
reason.
negotiation.
Right.
Okay, well, I think we're getting, yes. Another comment from the public? Anybody got their hand raised? No.
Thank you, Cheryl Lindbergh. First of all, you don't always go into executive sessions with an attorney. You've had executive sessions where you've gone in on your own. So to think that an attorney would be present to lead you properly into an executive session seems to be not always possible. So I have sat through many a year of select board meetings and observed a lot. It seems to me lately that it doesn't feel like the select board knows it's the select board's meeting. It feels like there's just some process being followed. I'm just looking at it from outside in. I've never been on the select board, but it seems to me that if you're going to have a meeting, it's your meeting and it's your agenda for that meeting and it's your packet. And before it's finished and sent to the public, you should know that you've done the right stuff and you've put the right documents into that packet to support any discussion that you plan to have. So important for the rest of us. And I can't urge you enough to be sure that you're in charge of, and I talk to you because you're the chair, I'm talking to all of you, but to discuss an agenda item in depth with opinions and comments is clearly inappropriate. That is, and I sit and wonder if each of you have sat and done the OML training. Have you all done it?
I'm sorry, but
Thank you.
you just said to discuss an agenda item in depth is inappropriate. What?
When it's listed here in this document, that there was a discussion, a number 5.
In email and text.
Yes. So I would say if you've taken the training, this is clear. I just don't understand how you cannot know that. The next thing that comes to mind is the $100,000 lawsuit. I mean, that was a big lesson in OML violation. We sat through that as the public in a grueling experience, watching the select board continue to spend hundreds of thousands of dollars. People begged the select board to stop. It didn't happen. And it settled. And I know in Mary's term, she was approached by the Attorney General's office specifically to say, you've had too many executive sessions, you need to do better. So to hear tonight that we now need to do better,
Well, actually,
I'm going to finish.
okay.
I will step aside. But it seems to me that at that point, and after the OML lawsuit was the time to get an understanding of how to do it right. How much do you need to have in front of you to understand how to do it right? You know, you expect it of all the committees and all of the other boards and all the other elected officials. So my comment is, you know, what more do you need? And if you've taken the training, which I'm glad to hear that you have, these are the important steps to doing it right. And the longer you're on the board, the better you should know how to do it. Right. So I just have to say these things because it's exasperating at times to sit and watch. So I appreciate it.
My first confession, I have not yet taken the training. It's pending.
That's great. And we are all supposed to do it too. The rest of us, elected officials and committee members should know. Your first thing to them is make sure you understand the OML. That was always the precedence to a committee being established. So
I'm going to go out there and say, you know, in some ways, we're fortunate to have people in the town who really know this stuff and who really care about it and who are holding our feet to the fire, right? In another town, a little more lax, we would never hear this stuff. You know, we're doing maybe okay, but we could do better. So we're going to try to do better. We're going to try to be the best possible example so that we can then solve the tax problem by going out, becoming consultants for the rest of Vermont, perhaps.
Well, my final comment, for those of you that have stepped into this brand new, those of us that have been here, get frustrated. And I apologize in a way, but it is frustrating. But to see that there was an agenda item about a draft audit policy with a possible executive session, that just doesn't exist. There is no executive session item to go look at and do that. But the one that was given is very different.
We're not discussing that specific case.
Well, it's in this. I'm just commenting before I leave the table, Mr. Chair, that there's a disconnect there big time. That agenda item and the reason to go into executive session, huge disconnect. That's a good example.
Thank you.
I think, I know you'd like to move on, Mary, to the individual responses where required, that curious requested, but I just wanted to point out a couple of things. So with complaint 5, where the individual bullet points are listed, the sound bites of individuals' conversations. I do not support this at this time. I'm comfortable taking an executive session if necessary. I think these sound quite reasonable. I don't think there can be too much controversy about that. But then something like, as I was not contacted by Pam Smith, Pam Smith was not on the select board. So what's going on here? Could this matter be discussed in public in a civilized manner? What's going on here? Like, are we being uncivilized, debating whether something goes on the agenda or stays off it? Number 5's got a lot in it. And I don't know that anyone, in particular me, knows it all because I haven't seen these unredacted documents. And that's the specific request of Mr. Katucki, is the unredacted documents of number 5. Okay. So that's specifically one of the specific cures to release the whole box and dice for number 5.
Yes.
And we'll just say that the redactions came during the Public Records Act request, and I believe were made by council as.
Is that true?
I believe so.
Yeah.
We didn't make those redactions, that council went over all the.
Well, we'll do redactions next
I'm
week.
just saying that council went over it, and there are exemptions where you can redact. So I would assume that that's why they are there. And if they are there, I mean, this is a question. We have our council right here. What basis were the redactions made,
So should we?
Is that for next week, though? Redactions? I don't know. Kino, what do you think?
I'm sorry?
Is the issue of redactions maybe something for next week?
No, I think we should talk about it this week.
You want to do it now?
Some
Okay.
document. Thank you for your patience. All right. I guess we have some questions, but perhaps you would like to comment on what you've heard before we ask you questions. I'm impressed you haven't run away screaming.
That's not my job. No, my job is to run at it. But I don't have any comment. I guess, what would you like from me now?
Well, I guess we can ask you questions.
Yeah.
I'd like to ask. So,
Are we asking for legal advice at this moment? Are we asking for legal advice at this moment?
Procedural advice, not a legal opinion.
Is that his area of
Let me,
responsibility?
before he answers the question, let me pose the question and he can tell us. So in the response records for the request lodged 2nd February 26 for all January 2026 email and cell phone text correspondence, there were 118 redactions spread over 318 pages. By which method was this redaction process implemented?
By reviewing the records against the exemptions in the Public Records Act and applying the exemptions in the Public Records Act to those documents.
So manually by a lawyer or AI?
Manually by a lawyer.
Okay.
Is AI review of legal documents even legal?
Who knows what AI can do?
No,
I just asked.
Well, maybe you don't want to answer.
but we're not doing that.
We're
So,
not going there. Okay.
you had some questions.
Well, just one of our items that we are asked to cure is to release to the public the January 23 to 26 emails without the redactions referencing 1 VSA 317C. So I believe our counsel is saying that these redactions were done properly under that statute, and Mr. Katucki is saying they're not. So where do we stand on that? And is that a proper reason to go into executive session? Because that might be a legal question.
So Mr. Katucki is not asking whether the redactions were proper in this OML complaint. He is asking, as a cure, his proposed cure is that regardless of whether the exemptions apply to these, release them as a cure for the alleged OML violation. So we don't need to go, it's going to be up to you whether that is the cure. Like, what Mr. Katucki proposes is not necessarily what the select board needs to adopt to cure these. He may still bring a lawsuit to get the cure he believes he would like, but the select board has the discretion to craft a cure for these violations that addresses the violation to the best it can, and adopt a policy going forward for every admitted violation, adopt a policy to prevent future violations. So those are the two parts of anything the town admits was a violation. It needs to somehow try to cure in its discretion the violation, and adopt a policy to prevent similar violations from occurring in the future.
I think the issue of redactions only applies to point number 5 out of the 6 points.
Right. Yes.
Just the one.
About number 5. Yeah.
Just number 5.
Yes.
I have a question, another question,
Yes, Mary.
council. How are we to, how are we to understand the allowable discourse that we can have as a select board as far as putting items on the agenda? How restrictive do we have to be in our speech? Or if you are able to, give some kind of guideline, it would be helpful to me, perhaps to the rest of the board. I mean, the statute says we're allowed to, prepare items to put on the agenda. How far down that road can we go in discussing whether or not it's appropriate to have an agenda item, or is it appropriate to have an executive session? How far down that road can we go? How are we going to know what to do? Just in general, not even to do with this, but.
Well, it's two questions you're asking, isn't it?
Well, I don't want you to talk about my question. I want to hear the answer.
So I can say what the statute says is that the conversations that involve a quorum of the select board, that is the number of people, of the number of members of the select board that are sufficient to take action. So with 5 select board members, that'd be 3 select board members in a conversation. That conversation needs to be about agenda setting and scheduling. Getting further into interpreting that, I don't feel comfortable providing hypothetical answers in public session, as that gets into more legal advice.
I have a
Okay, thank you.
question. If we had put those email and text discussions into the packet and made them public, there would not be an issue. Right.
Well, if we assume and have the hypothetical, we haven't admitted that that conversation is a violation, but if we assume, say the select board talked about a full agenda item over 50 emails or something going into detail about the agenda item, just publishing those meeting minutes doesn't take away that there was a violation. Discussing outside of a warned public meeting is a violation. Anything besides agenda setting and scheduling.
Rob.
So my interpretation of open meeting law requirements are that any 2 members, less than a quorum, can communicate with each other about topics in the realm of municipal government. Anytime that 3 people show up as addressees, then you have an issue. My understanding would also be that in the process of discussing with the chair agenda setting, one could add your reason for wanting something on the agenda, as long as it's directly between one person and the chair. Does that seem to jive?
One person in the chair, yes, they could. And I've been thinking about this in the way the open meeting law is set up. I don't think you need to have everyone vote on whether an agenda goes on the agenda. I understand that's the chair's decision to set the agenda. And then that's why that's why the open meeting law says the first item of business is to add or delete things from the agenda. That provides the full board the authority to check the chair agenda setting and say, well, the chair didn't agree that this should go on the agenda, but I've got 3 people that agree that this should go on the agenda. So the first order of business, we're going to add it to the agenda. I mean, that's how I understand it working, and it kind of prevents some of the conversations of having to have everyone see, oh, I want it on the agenda, I don't want it on the agenda, that kind of conversation of why it's on the agenda, which is probably better had in open session.
Yes, I share some experience, and I'd be interested, if I may, to describe it, and I would be also very interested in the attorney's view. I hear the problem, and I've been through it many times. I was chair of the State Board of Education for quite a while, and it was my job, like it is your chairman's job, to build an agenda for each meeting. And then I would be doing this, and I would get a call from some group that wanted to be on the agenda, and it was already pretty crowded. And I'm thinking, well, do we have room and all that? And so I resorted, with guidance of the attorney for the State Board of Education, but I'm really not really sure that it was correct. I resorted to sending a note to the other 11 members of the board, saying, I've gotten a request from the Teachers Association to be included on our agenda, but that would mean we'd have to push off something else. What are your views? Do not reply all.
Right. Yeah. Absolutely.
And once only, don't go back and forth. So you are the pivot point, and you're inviting people's views, but there's no conversation. It's a one-way back from each if they wish. And if they don't, and nobody's telling anybody else what they're thinking. So it's one and one, one and one, one and one. And you make the call. And don't worry about whether everybody agrees. That's just, count. Now, I would like to, maybe the attorney would say, that's not a very smart way to do it, and I welcome that critique since I'm no longer chair of the State Board of Education.
Is that possible? What was described?
Yeah, if nobody replies all and they reply only to the chair with, hey, I think we should put this on the agenda because we said we were going to address it and haven't done it for two months. And it's just to the chair. And then they don't go and say the same thing to five of the four other people. That should be fine.
Okay.
Rob. So the conversation one-to-one with the chair about setting the agenda items should be on, shouldn't be on. That's one thing. If then I decide that I think it's very important, this proposed agenda item, I can individually, one to one other member, not to all, but one to one other member, ask, do you think this is appropriate to have on the agenda? Which would be a method of discussing in a non-quorum way, getting something on or off the agenda in a legal way, according to the open meeting law. I believe one-to-one conversations without a quorum are allowable in just about every sense. Would that be true?
It depends.
Okay.
I'm sorry, but
yeah, that's fine.
It depends. There has been case law out there, not necessarily in Vermont, that says, well, you can't go around it by sending the same email or having a conversation with everybody individually. That kind of there's limits we'll say there's limits to how far that can go.
Right.
Hypothetically, there are some limits.
But strictly speaking, I can converse via email or in-person conversation with one at a time and not boilerplating my email or whatever with other members of the board if I'm trying to get feedback from them or encourage them to take a position on agenda setting in open session.
Generally, yes, but there may be circumstances that it wouldn't apply. The facts involved, it really depends on the facts.
And you would never say, well, I was talking with Matt and he said,
right,
when you're talking to me. But are you asking if you could have the same conversation with more than one individual as long as you don't disclose what your first conversation was to the second?
I would say so, yeah.
Oh.
I mean, I think that fits. I would, from my understanding of the open meeting law, that is acceptable discussing with an individual on an issue. Another member of the board is one-on-one is an acceptable action. And it's, in a way, it's the only way that deeper understanding of issues could happen out between meetings.
Yeah. I mean,
but anytime you put a quorum in the list or duplicate the exact thing with multiple people, you're outside of the law.
Yeah. Okay.
Just one last thought. Back to that do not reply all letter. The reply that somebody could say is, I think, I think it ought to be on the agenda or whatever, and I think it ought to be in an executive session. So that gives you some input that says this thing maybe ought to be on like executive session. Since you're not, it's a bit of a pity that you're now being, I think, correctly directed to say probable executive session when you've always said possible. And probable implies that in all likelihood it will be. Possible says it's up for grabs. It
proposed
as opposed to possible versus proposed.
Right.
Or probable and proposed. And that's something to discuss perhaps with others as to whether or not you can substitute the word possible for probable. Mr. Katucki is taking issue with that legitimately. But in any case, if you were able to say possible, then if just Rob said to you, yeah, I think that ought to be on the agenda, and I think we ought to be ready to go into executive session, you could say possible, and even though nobody else has thought that.
So would you be allowed or would you be advised to say why you feel that way, or you leave that part off?
Well, that probably has, no, you shouldn't get into that. That's what you would talk about in the public session. And Rob would make his case for it being an executive session, and you would all vote on that.
Okay.
So the beauty of possible is that it's not a commitment. Unfortunately, when you have to say probable, well, that implies that there's almost a consensus of some sort, and that's a different matter. I don't know how to get around that linguistic obstacle, but in any case, an email that is no reply at all, people could say anything they want. You could say, well, I think we ought to go to the Red Sox game.
I think we've already come up with the cure for the proposed possible, issue, which is now we're going to say possible proposed executive session, covering all the bases and leaving open for our choice of it or not. that one is probably the easiest thing that we have to talk about.
And there's nothing in the open meeting law that requires you to put executive session on there to allow you to have an executive session.
Ah,
Is that right?
Yes.
I thought it had to be on there. I thought we.
No, it only says if you put executive session on the agenda, you have to say pose it.
Oh.
The way to get into executive session is you make your motions, and if the statute doesn't that proposed executive session language, the statute says if executive session is put on the agenda,
It has. Oh,
and that.
Okay. That's interesting.
But a lot of the public likes to be warned about an executive session to decide whether or not they're going to stick around or when they're going to go. So that's probably more the origin of why it became practice of putting it on the agenda.
Right.
But usually,
certainly,
yeah, go ahead.
I'm sorry, if we were inviting you to a meeting and we didn't say there was going to be an executive session, people would be upset. Oh, you plan to have a lawyer there, but you didn't tell anybody? That wouldn't be.
Yeah, I'm not telling you to change practice. I'm just saying, there are options in that there's nothing making you do it.
Okay. Okay. Are there any other questions? Yes, Mary.
Yeah, I could ask this of Mariah if possible. So one of our requests of Mr. Katucki is disclose the nature of the legal dispute regarding agenda item 6. And I'm not sure where the word dispute came from, but if there is a legal question about some kind of action by another municipal body or another public official, how private should that be? If we want to know more or just to understand what our legal position is? Like, could we go wide open with almost anything, any question that we have or not?
If you're asking for legal services by me, you can go into executive session to receive that advice and legal services.
If it's a legal question, we are allowed to go in to receive legal advice, right?
Yes.
But then, is it our judgment about whether that's necessary?
It's always your judgment. Yes.
Well, it's always our judgment, but how do we have good judgment about it, I guess is what I'm asking. You might not, it's like you say, it probably depends on the facts, right? The situation. So,
yeah.
I'm just thinking about number 3.
Yeah.
So are you asking also if we need to mention what we're asking for advice about?
Well, Mr. Katucki would like us, the board, to disclose in order to cure a violation, to disclose the nature of the legal dispute regarding agenda item 6, which is about the fire district tax exempt properties.
Mm-hmm.
And I'd need some more information from the board that I think would be an executive session providing me information.
So you were saying that you think that's an appropriate topic, or that allegation would be that we would be protecting the interests of the town by getting the legal advice before making a decision on that?
I'm not opining out in open session right now on anything that is alleged here.
Okay.
Now. But if you wanted my legal advice or legal opinion on something, you could, there's a process, and you make a finding that the board risks waiving attorney-client privilege if it has this conversation in open meeting, and that is a substantial, could put, likely puts the board at a substantial disadvantage.
Right, and we've used
By
that one a
waiving-
lot.
Yeah,
We've used that one a lot. And I think it's just to get basic legal advice when we have doubts.
right.
So to me, I like getting some advice. I could go on my gut instinct, but I don't know if it's always a wise course of action.
Can you be clear about what?
I don't think we get into the specific topic, really.
I think you do.
Sort of the chicken and the egg.
Yeah.
Like, I mean, in a way, all of these allegations come from these basically two agenda items that I kind of wish we could just have discussed in public
Yes.
what they are, but I don't know if it's even in curing them. Do we need to reinvent the wheel and just discuss them again in public? Would that cure it? Is that advisable? Cure them, I should say.
You have a hand up.
Just to remind you that if it's not permissible to simply assert that you find. You must give a reason for the finding. Finding, remember, we spoke about this. Finding is a conclusion based upon evidence that's been presented. I see that it's snowing out there, and it's blowing pretty hard. It looks like very small flakes of snow. That must mean it's colder than 32. I find that it's below 32 out there because I had evidence that I drew upon. What your habit has been is to not present any evidence, but merely to say, I find. I find that there is a risk to public interest and so on and so forth, the language from statute. The example I gave to you, you recall you went into an executive session to talk about the Trussell lawsuit against the town of Norwich. You wouldn't even say what the lawsuit was. There is this habit of needing to keep everything secret.
And all the while it was in the public domain.
Precisely.
And we didn't know that.
Well, it wasn't at first.
Well, at the moment it was on the 23rd of December, it was in the public domain.
Yeah, but it was before it was done. Can I ask a question about that? So I would, specifically for that topic, I wasn't sure if it was legally okay for us to talk about a pending legal case.
To refer to it?
Yeah. It wasn't to try to hide it. I think the assumption is made that somehow we were trying to be secretive about it when it wasn't. It was that we're told we're not allowed to talk about either a pending or an ongoing legal case against the town, and that seems like standard vernacular for telling us there's a legal case. We can't talk. If a Valley News reporter calls us, we can't talk about it. We can't talk about it. So then to kind of hold against us that we didn't talk about it seems awfully unfair.
I see.
And maybe to flip that, if we knew that it was okay and good to just reference the case, I'm sure we would have done it. And so that's where I appreciate this discussion here, because now we know that. One of the times that we went into executive session, it was a pending case. So in that case, I mean, I don't know. I'm assuming that we're not supposed to talk about pending cases. So that's hard.
Sure.
And the inference is that we're trying to be sneaky, but truly, none of our members that I've had past or present, seems to be sneaky.
Sure.
We're just trying to do the best that we can.
Sure.
And it's a little bit frustrating too. We're presented with sort of legal statute that people are referencing, but the legal statute itself is somewhat ambiguous on exactly what we're supposed to do, exactly how we're supposed to title our agenda items, and how much information we're supposed to give in advance. And I'm listening here, and a lot of our members are sort of asking for clarity, and the answers are not clear at all.
Agreed.
Like, and I get that, but that's kind of statute, right? But the take home message I think that we feel is be as open and as honest and as comprehensive as we possibly can in dealing with the public, both in advance in our packets and our agendas and then in session, and only use executive session when it's absolutely necessary. But sometimes we don't know whether it's sometimes we need legal advice, and ahead of hearing that advice, we will not know whether it's completely necessary, but we need to make an educated guess that it could be necessary, and therefore we need to go into executive session, hear the legal advice. I guess if we get done with it and we feel like it wasn't necessary, we could come out of session and just say, here's what you talked about.
Sure.
And I think we're all here. I think we're all hearing what if that's on target.
I hear you too. Nobody's trying to be sneaky, that's for sure. I think it's sort of how fully shall we disclose? And I just want to read to you the example I wrote for you, because maybe that will help. If instead of just saying the board wishes to go into executive session to discuss I think you called it pending litigation. Of course, it wasn't pending in the sense of it hadn't been filed yet. It was pending before the courts, but it's litigation. Anyway, what I suggested to you might have said was, in late December, a former employee of the town, Judy Trussell, filed suit in Windsor Superior Court against the town of Norwich. Ms. Trussell's complaint is a public document titled Trussell v. Town, and it may be found and read by the public on the court's website. Now, here you're sharing with the public that they have access to this information. So that's useful, I think, to assure people that they can see what this is about. And then you would go on and you say, in the suit, Ms. Trussell alleges misconduct by certain officers and employees of the town. Notice I didn't even name the officers or employees, even though they are named in the suit, each of whom is named in the complaint. Inasmuch as it is the public document, board members have read Ms. Trussell's filing, and that, by the way, I may say, you need to be reading this stuff before you sit down and spend an hour with an attorney and leave this room empty. If you're not reading it, then the attorney has to explain everything to you, which is pretty much an insult to everybody else. So read the stuff, please. And then the town's attorney has advised the select board of the need to file with the court a response. I'm just making this up. I don't know why you were meeting with him, but probably you had to do something. And the attorney has drafted possible options, hopefully, and then for the board's consideration and direction. Purpose of this agenda item is for the board to review the options proposed by the town's attorney, to evaluate them, and to provide direction to the attorney as to how the town wishes to respond to the Trussell complaint. You're now at least setting a context for people as to what the hell is this all about?
Yeah.
But you haven't revealed anything that would embarrass any individual, since you haven't named anybody. The suit itself may be embarrassing to certain individuals, but nothing you can do about that. Yeah. So all I'm just saying is it can be done and still not go too far and reveal or embarrass.
And Matt, you're asking, how could we have known this?
Well, I'm not necessarily referring to this one specifically.
Understand.
To more of the generic ones where we need to hear legal counsel. We need to hear the legal counsel before we can know whether or not we want to waive, like, the attorney-client privilege.
Another possibility, if I may, is for your chair to be in touch offline with the legal counsel, not your town manager, your chair. And your chair could confer with the council, and the council could say, yeah, that's pretty sticky stuff. We could get in the muck real fast there. You better go private on that one.
Okay.
Or the council might say, well, if you or might advise otherwise. So in other words, I believe that if you vest your chair with authority of that sort, and you certainly can by vote, in effect, you're delegating to the chair to do something on your behalf. You do delegate to the chair to put the agenda together, And then the chair comes back and reveals to you in public session. Now, it doesn't write to you about it privately. Public session says, I've conferred with the attorney, and he recommends that we go into executive session. That doesn't shortcut the need to inform the public in some, and give context, such as I'm giving you an example of.
Right.
But
then he can help draft, he can help put into context because he's already created, he's already been informed enough to actually.
And by talking to the chair, he's now got an understanding as to where the tender issues are and why we need to do this.
Okay.
So I think you could do that. I say the chair as opposed to the town manager because the chair has executive authority in matters such as this, and it is a matter before the board. On other matters relating to individuals who report to the town manager, that's a different matter entirely. Okay, that's helpful somehow.
Thank you. I think it is.
Yeah, thank you. I think there's Chris. Please.
Am I
You
on?
have your hand up.
Hello,
You're
people. Well, Mr. Chair, I just want to make a comment. And I know that Chris put this in there almost as the last word on number 6. Specific cure requested is Trombley. And I'm going to emphasize it again. Trombley is really important in this executive session discussions. There was a court opinion. It's a precedent that has been set. And it is really clear. It's been out there for years. And again, not to make an offense to this town, Chris and I and other people in this town have tried to tell you guys to read Trombley and understand that there is a very specific steps to follow. It is not just read the preamble of what the statute says. It says Trombley definitely Trombley addresses that it on a case-by-case basis. You all are responsible for doing a careful analysis before you go into executive. John's been trying to tell you this. It's good to have him bring up some examples, but you guys have not done case-by-case analysis as Trombley is suggesting. Chris, again, has been telling you guys this over and over again. So I would suggest you guys get yourself versed in Trombley. I'm sure Brian would be able to explain it to you that case.
I don't think you'd like my opinion on Trombley. So.
Well, again, Trombley to us, I think, again, not gonna get in a legal dispute, but they're according to the court opinion, that Trombley means that you can do a case-by-case analysis. So.
Okay, thank you.
That's it.
I'll try to find it and get it out there.
It's easy. Yeah, it's easy enough to look it up. I have a copy if you want it, Chemo.
Thanks.
But I just want you to know that Chris, that is what Chris was requesting in number 6.
Thanks. Your hand is still up. Okay, thanks. Do we have any other questions? No other questions. Let's go through these cures. Acknowledge the description of the meeting agenda for items 6 and 8 did not satisfy PSA section 312 D3.
If I can interrupt.
Yes.
So I just got this today anyways, but it appears that these are all questions specifically about the email communications. That's where this all is based.
All 6?
All 6 of these things, January 23rd through 26th, 2026, in a quorum email exchange. And with the the 28th meeting also. Okay, yeah. Sorry, I'm stopped at the beginning. So these errors were both the email communication and the meeting. Also,
Which number are you?
I'm looking here at the beginning of the notice of open meeting law violation.
Oh, I was looking at,
But I'm just in context. It's my question was, if those had not been reply all, if that had not been discussed in emails that represented a quorum discussion, how much was in the meeting itself up to January 28th?
okay,
So maybe, so I guess that's
What number?
most of it would be.
Where are you looking on here?
I'm looking, the 1, 2, 3, 4, date and time of occurrence.
Date and time of occurrence, January 23rd. Okay, so at the very beginning of the document is where we're looking?
Yes, yeah. So January 20, I was just curious. I was not reading completely. A lot of it seems to be, it's not defined as to whether this is all stuff that happened in the meeting itself or exactly if it was in the emails.
Okay, so I think it's both. It was in the quorum.
Yeah, it's both. And so I'd have to review the meeting to get a sense of.
And in the connection with it. And so in connection with, I think, means everything to do with that meeting, leading up to it, during the meeting, perhaps.
But as far as the specific things, is this describing the agenda as published for the January 28th meeting? Or is it the discussion about the agenda?
Both.
28th.
Yeah,
So
It's both.
everything.
So number one is specifically a single agenda item.
Right.
Number two, same. Number three is a amorphous dispute that's not clear. Number four is a vague reference to disciplinary or dismissal action that seems out of context. And Mr. Katucki thinks 313A4 is the inappropriate statute to address the issue VSA 313A. So he sees a disconnect and inconsistency in 4. Number 5 is a very complicated, very protracted email thread question.
Right.
To your point, Rob. So
so
that is all email exchange, number 5.
Right.
And that's it.
Yeah.
Yeah. So I should open up.
Have you had a chance to look, even though we're not discussing it tonight, have you looked at the emails? The redacteds?
No, I saw them. I didn't get a chance to read them.
We'll meet up for next week.
We have a lot of time. We plan a lot of time.
Yeah.
There's a lot of
It's a lot.
material.
Hundreds.
Yeah.
537 pages.
It's not necessarily all relevant material, but you have to sort through it.
And I think the quoted lines here are perhaps both from emails that were sent possibly inappropriately to multiple people, and some emails that were just simply sent back to, one of these I sent back to Mary.
Yeah.
And nobody else.
Right.
But that's in here because I think it expressed an opinion that perhaps I shouldn't have expressed. In other words, mine's the first one, I do not support this time. And then I told why I didn't support it.
Right.
But it wasn't a mass mailing.
It wasn't in a quorum.
Oh,
So
no.
is an opinion acceptable if it's not in a quorum?
So there are a couple of different complaints there, which, but I'm trying to move on now to specific cures and decide what we want to do.
Cures are these acknowledgements are for expressly for the errors that got expressed, that got listed in the agenda for the meeting, for the open meeting. The release and disclose. Well,
Yes.
disclose would have been the meeting also.
Description in the meeting agenda
Yeah.
for items 6 and 8.
Right.
So for me,
Yeah.
that number one, acknowledge that the description in the meeting agenda for items 6 and 8 did not satisfy 1 BSA 312D3 that's semantics. Yeah, yes, we should have said proposed, and we didn't. We said possible.
Okay.
So, okay. And now we know that we don't actually have to write anything, but I think we should, announce when we are going to, when it is possible that a proposed executive session will happen, or yes,
Okay.
will happen.
So we can have a motion next week to acknowledge this, which is what's being asked.
Right.
That one is.
But there is also the second paragraph, Matt, that does talk about sufficient detail.
Wait,
But I think that's mentioned more in 3 and 4 about sufficient, like that we didn't.
Oh, yeah, right. Yeah.
That we really didn't go into, I'm sorry,
well,
Trumbull.
we're just looking at the end of the document now.
We're just looking at-
I'm going past on the specific complaints, going to the end.
Cures.
For the cures.
So number one's very
This is what we-
specific.
This is what we need to act on.
Seems like, okay.
That seems
semantics,
reasonable.
We should have done it. It was in statute. We just didn't say the right word.
Okay,
So that's number one.
we might have a motion to acknowledge that.
Sure.
Number 2, we could acknowledge select board's explanation, the reason going to executive session did not comply. Perhaps that's arguable. I don't know why you would argue it.
That's the insufficient detail thing, right?
Yeah,
That's a
what
trickier one.
Chris was saying, well,
trickier, but
about Tremblay and doing careful analysis beforehand.
but there's one that, it could be interpreted multiple ways.
We could say we could try to do better. I don't know if we'll actually be able to meet that standard.
Okay. But so should we have a motion acknowledging this to vote on?
Aren't we doing that? Isn't there an agenda item
Yeah.
for the next meeting
next
to
Wednesday.
actually take action on this,
Yeah.
right?
Tonight, just to let you know, tonight, what you need to have done before April 19th is either acknowledge or deny that there was a violation for each of these. We have
Okay.
another 14 days from today. If we acknowledge or deny, we have another 14 days from today to come up with how we're going to cure anything we acknowledge.
Okay, so if we acknowledge we need to cure. And if we don't, there might be further.
Sorry, is that like an additional 4 days or an additional 14?
14 from today.
14 from today.
Okay.
Right.
So if we,
Acknowledge any of these, you have 14 days to institute the cures and policy.
right,
Okay,
okay,
from today we have 3 days.
14 days. Another 14 days from today.
well, if we waited till the 18th stroke of midnight or something, and had a special meeting.
No.
We have to acknowledge within 10 days or deny within 10 days. We have to respond to
Right.
within 10 days.
I have an email from Mr. Katucki extending the deadline to the 22nd.
To
So-
acknowledge or to,
Yes, I believe to acknowledge,
right.
but I don't mind doing it here.
It also might, this was an information gathering session. Like, I feel like we've absorbed a lot of information right now. I would love to think it over a little bit more before we choose to acknowledge or deny each one of the claims here, because I feel like a lot of these, I don't know. I know we can't do this, but I could say that number 3 and number 4, I acknowledge that we could do it better, definitely. And we've talked about how we could do it better, but I'm not really, it's not really clear to me that we didn't do it correctly. That we didn't satisfy all of the sort of the VSA criteria for it. And we did it pretty well, and we should do it better. But if saying that we did it incorrect, I'd like to think on it more before I say we did it incorrectly.
Okay, so I have an email. Hi, Chemo. Thanks for getting in touch. I'm willing to wait until April 22nd for a response.
Okay.
Okay.
So I think, to your points, Matt, I think 1, 2, and 4 are the acknowledge requests. And I think they can be potentially more straightforward than the other ones, number 3 and number 5. Because 3 is a disclose the nature of the legal dispute. And that is not a statute bound thing. That's may take more time, possibly. I don't know.
What's the difficulty with that?
I don't know. That thing seems so benign. It was like, sure, whatever.
Yeah.
I don't know.
What would the response be? I don't know.
I didn't hear that.
Number 3.
Yep. No,
Disclose the nature of the legal dispute regarding agenda item 6.
yeah. I have to go back and see what that was supposed to be.
I mean,
You guys were
it's like-
there, but we
is there
were.
any reason not to talk about that? Yes.
So, memory serves, we had in the packet a legal letter from the Prudential Committee's attorney. That was clearly what we were talking about.
Yeah, it was announcing.
Session, so we're gonna go talk about this. We just don't understand what we should be doing.
Yeah.
So
The select board hasn't taken a position on that letter to date that I'm aware of.
But to clarify, it seems like there's a lot of confusion about was something done improperly or not. That's not for me to say, that's for the board. But I think the crux of it is, if nothing occurred that was against the statute of the Vermont open meeting law, then the deny would be the logical solution to me.
No. But the number 3, the nature of that dispute has already been disclosed in the letter that was in the packet.
But you'd have to acknowledge that you had you had violated the open meeting law in order to cure something, I believe.
Well, this just, number 3 just says disclose the nature of the legal dispute, and we can do that.
Well, if you denied all 3 of the claims that you had violated the open meeting law, then I don't think you'd be curing anything. So I think
But I'm going point by point here. We've looked at 1, we've looked at 2, I'm looking at number 3, that asks us to disclose the nature of the legal dispute. What I'm saying, I'm not talking about open meeting law. I'm talking about, he's made a specific request to disclose some information that I believe was already in the packet. And I don't think we have any reason to not disclose that.
I think it's been so. I guess that's my.
So
The letter was already in the packet.
We can agree to disclose that, I think.
It's already been in the
Like, there was
public.
nothing.
We could refer back to the packet.
Okay, so maybe it wasn't clear, but if we did disclose it, it doesn't hurt anything, right?
Reference the packet.
Well, I mean, it's sort of saying there was a legal dispute, and that is sort of I don't know.
Nature.
I don't think it makes sense.
Yeah.
The letter is in the packet.
See the packet.
Chair,
Then,
Mr. Chair,
Yeah.
it's really hard to take minutes when everyone's talking at once. So if you could.
I will
ask everyone to
recognize.
recognize me first, we can do that with them.
Thank you. I'm sorry about that. All right, so we have a comment.
I have the minutes of the meeting here. Would that be helpful to you?
I printed them and then forgot to bring them. Of the
discussion that preceded each of these executive sessions.
well, there is item 6.
That's a different matter.
Yeah, that item 6 refers to something that was described in a document that was in the packet. So I don't know why we're saying it wasn't disclosed, but if you just read the agenda, it doesn't disclose what the legal thing is, but the packet includes.
According to the minutes, you did not disclose
Correct,
the contents of the packet.
correct,
And meeting is what counts, not what is in the packet.
right. But because it's been put in the packet, it's a public document, there's no reason to fight disclosure. We can go ahead and disclose this, right? I feel like I'm not making any sense to anybody.
yeah, no, if I may.
Yes.
So the historical document, historical the $100,000 lawsuit got started because one of the reasons it got started was that it didn't seem as if some of the complaints were in any way valid. So how does one acknowledge an error in something that you don't necessarily think is valid? The actual request for a cure. So for instance, this example of disclose, well, are you admitting that you didn't disclose it, so here it is, or just reference, we're denying that this is a violation because here is where. So in effect, that would be giving it denial for that particular one because the packet was public and that information was in the packet. But
Okay.
was it more clearly referenced to before the executive session? That I don't know. And did it need to be, since it was public and in the packet?
Okay, so we may have failed in the packet to state exactly what we were going to be doing. However, we can cure that by disclosing what it is that we were going to do. They're not asking us to change the language. You're just saying, disclose the dispute. No, you're saying.
May I, if you read the minutes, which we have to trust is an accurate accounting of the meeting because you've approved these minutes as being such, the minutes in connection with item 6, you'll see that the minutes simply don't explain why you're going into executive session. It begins by saying the chair stated that she would welcome the chance to discuss the letter in executive session due to legal questions. Vincent shared confusion at the interest in entering executive session, blah, blah, blah. And then the chair responded that it was a transition and a difference historically in the relationship between the fire district and the town. I'm sure an accurate fact, but that doesn't present any evidence as to why one needs to go into executive session. It's an interesting fact. And then Callaway went on and stated that there were no approved lister minutes, only draft minutes, and then questions about the PVR. And Callaway explained that she wondered how the final decision was arrived at, or whether the listers got advice of counsel on PVR 317. She noted 7 properties listed, and that the matter of the final should be discussed in executive session. She asserted that it should be discussed in an executive session. And then she moved. I moved to find that premature public discussion and so forth. So again, it feels more like assertions by one member that was about the PVR and whether or not it was up to date and so forth. Then it's hard to see how that, it wasn't exactly why that needed to be discussed in private. And that is the complaint in number, I think it's, I've lost track of Mr. Katucki's numbers. That would be
Number 3.
Is item number 3.
But beware, there's 2 specific references here. One to the historic relationship between the town and the fire district, as well as comments by member Callaway about actions by the listers,
Right.
which seems unrelated.
Well, they both were made here. And these were the statements by the members. And I think the concern would be that those are interesting facts and concerns, but it's hard to see how that finds that, quote, premature public knowledge of potential litigation would place the select board at a substantial disadvantage, including by potentially disclosing confidential information. That was the claim, that if we talked about this in public, it would place the public or the select board at a potential substantial disadvantage. I have no idea, of course, what was discussed, but all I'm getting at is, again, there does seem to be a lot of expectation in statute and in the Supreme Court case that you need to explain what this is about.
Mhm.
And this doesn't seem that the evidence presented here isn't an explanation of not only what is this about, but why it is so delicate that it can't be discussed in public. And that's his complaint in number 3.
I'm going to stop discussion only because what is being asked for us to cure this is simply to disclose the nature of the legal dispute regarding agenda item 6. The letter in the packet on January 20th discloses the legal dispute, right? Norwich Select Board.
Is there a legal dispute?
I don't think so.
I don't know why it was written, but that is the.
I mean, I
that's what
think
we're being asked.
I'd like to, you know.
Isn't that what we're being asked to do? Item number 6, yes.
I just think I could provide a lot more clarity if I could kind of opine and give our advice on this, and you can take it or leave it. But I mean, that would be an executive session, but I think it'd be a proper executive session to get my legal advice.
Well, if I can just, in the agenda on the January 28th, number 6 is Fire District Tax Exemption Agreement, possible executives. On page 7 of the packet is a letter from the Prudential Committee to the Norwich Select Board setting out what the disagreement was.
And there's not, I don't believe the Select Board has said there's a disagreement. The Select Board hasn't come down either way on what that letter says. The letter is saying to the Select Board, we, the fire district, have taken the position that our development rights, which we granted to you, have reverted to us. That's what the letter says. And the Select Board hasn't taken a position on whether or not those development rights have reverted back to the fire district.
So you're saying the dispute isn't.
There's not necessarily a dispute.
Like we took that, we went into executive session to get potentially legal counsel, and that, but there may be something.
Okay. Is there any reason we can't disclose?
I think I just did.
No, you just said maybe that one's cured.
Can we be done with number 3 by saying yes, we can disclose?
Not real. You can't be done because you need to either acknowledge or deny the OML. We've already provided the cure, but you still need to say whether or not you acknowledge or deny the OML violation.
Does the word dispute appear in the letter?
No.
I'm confused here.
In this?
So is it or is it not a dispute?
I think
the Select Board, we don't know yet. The Select Board hasn't decided.
But it says, it tells what the disagreement is. That there was a decision made.
No, it tells their position.
Just gives it, yeah.
The letter is from their attorney. Let's
Right.
be clear. It
It's
is
a legal letter,
All right.
and we were going to our attorney to get legal advice. I'm not.
Okay, so
I'd
what?
say no on that one.
No to disclose the
Personally.
nature of the
Well,
legal
Because
dispute.
I don't think it's, as per I was, it's not a dispute.
We have
Well, I have a lot of advice, and I need to go over things with you about these to provide you some, candid legal advice and analysis on these, which, regardless of what we do or decide, Mr. Katucki could still bring a lawsuit. So all of my analysis could be used against us. So that's all I'm saying. I could provide a lot more in-depth advice and analysis regarding these allegations that I think would be useful if you'd like.
Yeah, but Bariah, there's one caveat here is that at least one of the Select Board has not seen all the redacted emails, all 537 pages. And I have not seen the unredacted versions, nor do I think has anyone on the select board.
Well, I've taken out the referenced emails, which I believe Mr. Katucki is referencing in his complaint, and I can email those to all of you showing what was marked as redactions, but you could still read it. There's only about 2 or 3 pages of those.
Well, that sounds
Or
straightforward.
actually, hang on,
That'd be
there
good.
is 63 to 60. Yeah, there's 6 pages of those, which I believe are mostly the pertinent ones that are referenced by Mr. Katucki from January 3rd to January 26th.
Mary.
I just have a general question. Are we being reckless in going through and making these decisions? I mean, we might kind of know how it's trending, but are we being reckless by not going into an executive session to also get a perspective of council? Are we being reckless?
I would like to add to that. I think what we have done, with your leadership, we have done a remarkable job at trying to keep this in the public forum so that we can ask as many possible public questions and get them answered for everybody to listen to. But we are also facing litigation. And I think that it's fair for us to also use executive session as it's meant to be used, to talk to our lawyer and get legal advice that may be used, that if we had it in open session could put us at a substantial disadvantage. I think there's also, I get that, it's actually kind of weird to use, we're trying to deal with how to use executive session appropriately.
Mm-hmm.
And we're not using it appropriately right now, because I think that we need to hear from our lawyer. We're trying to make decisions with as much information as we possibly can, and facing 5 alleged violations. And I'd like to hear everything that could possibly be said by all the subject matter experts. And we're I don't know, we're making it harder for ourselves at this point.
I think further to John's point about being informed with all the reading before you engage the attorneys, I think in this case, I have nothing whatsoever about comments by Member Callaway about actions by the listers. I have no idea what that means. Absolutely not. Now, we could go to executive session now and have Mariah give us some advice on that, but I won't have known it. And I don't know it now. And nor would Rob.
I think that's a good point, but I think you could do that research in addition to that. We could get advice from council. In fact,
and retroactively, I could chase that.
Well, I mean, because we're not.
Down.
Okay.
I don't have a problem with that. That's fine. So long as I can get to read it.
We have till the 22nd, right? We have an extension graciously offered by Mr. Katucki. So you could hear what council has to say. You could chase down the facts that you want to review. I think you'd be okay.
Sure. So after the fact, but I'm okay with that.
Well,
I can catch up.
It's not really after the fact, because I think we just
an opinion without the facts.
Well,
I can get you guys the emails. Like I said, there's 6 pages, I believe, of what Mr. Katucki is referencing, and I can get you the minutes from there and the video link. I don't know. Mr. Katucki referenced a transcript, but I don't have a transcript in his email. And I can get you all that if you want me to come back on the 22nd for my advice.
To come back for an possible proposed executive session on the 22nd, rather than to go in tonight, is what you're saying.
I think that's reasonable.
Sure. That still gives us time. I think that there's a lot of processing, at least for myself. I'd like to take what we've learned tonight and think more about it.
Okay.
We should certainly use executive session as little as possible. but that doesn't mean that it might not be appropriate
Mhm.
in this instance.
Oh, I think next week is almost certainly to be needed.
Sure.
So
let's not even
I
put
think,
off
I
the
think,
ball. Let's
I think
put-
we're, I think we're doing our best effort to try to like avoid doing it.
Hmm.
And we've come to the end of that.
Agreed.
oh, we have a public comment.
Just a question, Mr. Chair.
Can you come up?
Yeah, thank you. You made several references to documents that describe emails. And Mr. Katucki has made reference to them too. Evidently, they were made available to him under a public records request. Are those documents therefore public?
In the packet for next week?
I don't think so.
I mean, they were released to a.
If there are any times, so copies would not be released.
I'm sorry.
I even let our attorney.
I'm sorry, what?
Question?
We make the
Redacted
redacted
conversation.
Public Record Act.
Email.
public record, the emails.
The select board can do whatever it wants.
Yeah.
With that.
So 500 and something pages in a packet. Is there some mechanism for making those visible without putting them in a packet?
For the public.
To the public?
Can I comment?
Yes.
So as part of that, this gets very complicated. This would really be wonderful if we could go into the executive session and talk through the nuances here. So that had an accommodation made to share those documents electronically. As you recall, there were $545 worth of time incurred to create those copies. So no, I don't think it's appropriate just to share those copies with the public at this point.
Okay, but my question is, can it be done? If we decided to do it, can it be, is there a way to do it before we decide on whether to do it? I don't know what our options are.
Aren't they by definition public records?
They are public records. Yeah.
So they cannot be withheld.
Well, I mean, you just have.
They have
Wrong
redactions
way.
here. But pardon? I'm sorry.
Wrong.
Yeah, so they have been made with redactions, appropriate redactions for Mr. Katucki. If other members of the public were to request access to them, they would have access to them, but they would have to request them unless we are going to enter into a procedure where automatically anyone who asks for paid services can then claim that those paid services are then freely available in that same paid form.
So they're available. They're public.
They are available.
If you'd like to pay for them, you could be provided.
You can view them, the public can view them from a computer terminal here. They would have to wade through them the same way that anybody requesting public access would have to do. But if you set a precedent that we're going to, do all this filtering work for free and then not charge anybody.
All right.
It seems inappropriate.
So if somebody wanted to access these, we could find a way for them to access them. Is that correct?
I think that's an attorney question.
If people wanted to access these records, they'd request them and we'd provide them either for inspection, or if they wanted copies, they'd get their copies and pay whatever the cost of producing those were.
Okay, great. I think that answers that question.
We're talking only about a few email conversations.
500 and something pages of documents.
I believe.
I think if you looked at
Well,
I
I'm
believe
sorry, maybe I misunderstood.
Did you say that there were 548 pages of emails before this meeting?
No,
That were created for the record.
The Records Act request was for the 2 months.
I'm only discussing the things that are referenced in this complaint.
Ah,
I'm only talking about
okay.
Mr. Katucki's complaint and the documents behind the complaint. And he referred to some conversations. And I'm only saying if he has public records of those conversations, why can't the public?
Yeah.
It sounds like it's 10, 12 pages.
Well, the problem is request number 5 is released to the public unredacted emails from Jan 23 to 26. So he wants more than what he's currently got.
But that's he's filed his complaint on the basis of documents he's received.
Yeah, okay.
And I'm only saying, well, can the public see these documents? Have you seen those documents?
Yes.
You have.
I've seen the redacted things that he has seen exactly.
You've seen redacted?
Okay, so we're just talking about the ones between January 23rd to January 26th.
Yeah.
I see.
Now, a question for Mariah, if I may.
Yep.
Does that time period specifically contain the emails that refer to comments by member Callaway about actions by the listers or not?
That,
Sorry.
and where's that? Okay. And member, is that in 4? The comments by Callaway?
It's in 3.
3.
First paragraph of 3.
That's talking about what happened in the meeting, what she said in the meeting.
Yes.
Transcript would be transcript or
minutes, probably. Minutes.
I'll ask you about number 6, the email exchanges, which he refers and asking, may we see to what he is referring?
I think that's a fair request. We provided the public with this document. We have not given them the backup.
Yeah.
So I will ask if those might be produced.
Are you just making a blanket statement for all of us on that? Because we didn't vote on this.
No, I'm asking the question, if they can be produced. Can they be produced?
They can.
Is it
If they can.
He's already said.
Not if
Select
they
board can
should.
choose to do it.
I didn't say if they should.
Okay.
Is it a
Saying.
so that we can discuss whether it should happen? And if it is a possibility, do we want it to happen?
And this is Jan 23 to 26 emails without redactions.
No, I think that what John is asking is the redacted versions that Chris Katucki has already seen.
Okay.
Should we put those in the next packet? And I think the answer is if we choose to, we can.
We can.
All or part thereof?
I would say the relevant stuff that's referenced in his number 5 complaint.
Okay, I
I've
guess
got
that's, yeah.
6 pages.
Yeah, about 6 pages.
Okay, that's fine.
That
seems reasonable.
I'm not sure. I mean, if you did it as a motion, I'd probably not vote for it.
So this is just the relevant portions, but still remaining redacted.
Yes, and I am not sure that you need to see those in order to understand what is being presented here.
I mean, the case that he argues in number 5 is that you don't need to read them anyways, because he's presented here exactly what he, supports his thing.
Appear to go beyond merely scheduling. Appears to exceed a limit exception. But what he's asking is that we release to the public those emails without redactions
With redactions.
Without.
The Katucki
redactions in place, yes.
That's what, no, Katucki is asking if they be released without the redactions. Oh, sorry. And by he, I meant Katucki.
Oh, pardon.
That is his request.
Yeah.
So based on what we see here, we have to decide whether we are agreeable to releasing those same emails without the redactions.
You're just taking a straw reaction, because were we going to decide this on the 22nd since we have the extension? Or you just want to know where everybody's at?
Well, I think I'm trying to understand what the request is. So we've had a request from the public to include the emails that are referenced in this document.
Is that different than Katucki's, allegation against us? I mean, you're talking two different things, like what to put in the packet.
What I'm saying
Yeah,
is
it's two different things.
It's two different things,
You
right?
get a case and do we need to provide the emails referenced here in order for the public to understand this case?
I don't think
I don't think it's
we do,
necessary.
because I think in all his entire bulleted items here are from the emails.
Yeah.
And he even says this makes the case for it. And I would, yeah. So I'm not sure that releasing anything more is going to add to public understanding more than just, in fact, it's actually more concise to read his number 5,
Statement.
What he's asking for is that we release to the public
Right. I'm
emails without the redaction.
Yeah, I'm not addressing the cures that he's suggesting. I think we're just talking about how to understand, number 5 the best. And I think that it's pretty well written, and it includes all the email text that was there that's relevant.
Yes, Mary.
So is this document proposed to be in the packet or
I think
not?
it already was. It was.
It already was,
in the
okay.
packet for tonight.
Okay, so that lays out I think that's fine. I don't think you need,
In order to understand the argument.
no.
I would question under 4 in our public agenda. Consider responses to alleged open meeting law violations by Christopher Katucki. I think what you're now discussing is a second request that's come in from another member of the public seeking documents. I don't think you can take that up tonight.
It wasn't warned. So,
However, yeah, you're right. It
wasn't warned. Right?
yeah, I think that,
It would be
yeah.
a violation.
Motion.
In any case, I think we have enough to understand what the point is, and so we can hear that or agree to or not. Okay.
So does that mean you're denying my request?
Well,
You shouldn't take it up.
because the request is not what we have listed on the agenda. Yes, for now. So I guess I suggest a written request to the select board that we can get on the agenda. Any other questions? An interesting evening. Okay, so what we are agreeing to do is to have more time. Is it possible to begin our meeting at 5:30 next Wednesday rather than? Yes.
So I could say, yeah, I can make a meeting that early. But there was a question about, is that also convenient for the public?
6?
Well, I'm just throwing it out there,
Yeah,
and they're used to us, starting at 6:30.
that's true. Yes.
So you have a public hearing scheduled at 6:30. I think it would be very difficult to reschedule this for to be included in this regular meeting. I think you could have a special meeting. That'd be the wise thing to do.
Well, we've already listed it in the agenda.
The agenda is not published, but I think the concern is
Oh,
you have a very full agenda, and you have a public hearing that has to start at 6:30.
Yeah.
With more. So if you want to have an executive session or discuss this topic, you certainly do that, but I don't think you can start at 5:30.
Maybe
Well, the clock's ticking. We got April 22nd, right?
Because it's not enough time, you mean? An hour isn't enough time.
I don't know. You can't rewarn the public hearing.
Right.
So you would have to have, if you started a special meeting
Yes.
earlier on that day
Yeah.
and second,
That's what I'm
to
asking.
do that, you would have to make sure you were
We'd have to be done.
6:30.
Yeah.
Because you have to open up the regular meeting at that point.
Yeah.
You can't extend.
No, I get that. I get that. I'm just asking if it's a possibility for everyone here, or I
I
understand the
will not be
public.
here in person next week with a family obligation, so that doesn't stop anything. You'll just have to figure out a place to hold an executive session.
So
Yeah.
I guess what I'm trying to measure is, go early, it might be inconvenient, but if we go till 10:30, it's also very inconvenient. So, my goal is to find a happy medium.
Here's a question.
just in organizing this, if we come early, does that also mean that we can finally have a chance to go into executive session to hear what council has to say, or do we want to do that now?
I think that would be,
If it's convenient, although it's 9 at night.
okay, I thought the general sense that we'd like to have more time to think about this before.
And have executive session at April 22nd, right?
Right.
But that's going to be a very full meeting. Can we hear what has to be said and get all this business done of deciding in an hour time frame before the public hearing?
I don't know. You could certainly have a 1-hour meeting and continue the discussion afterward, later in the meeting. So get your legal advice and then do the rest of the work. I'm just looking for options. I don't have a,
Well,
I
it's gotta
can
be done by-
I can certainly get through my legal advice alone within a half hour, I believe. Whether
Okay.
your questions will come up, because I will also be eliciting some facts from some members of the select board as to what was actually discussed in these executive sessions to help with my analysis. So depending on how that goes, I would say a half hour to 45 minutes for my legal advice, depending on, and then what questions you might have. There might be more, but at the same time, are we going over cures as well? Or are we saying the 22nd is our acknowledgement? Mr. Katucki was gracious enough to give us that extension. We'll have another 14 days to work out the cures and draft potential policy for your review.
That's sounding reasonable. Maybe an executive meeting, 6 till 6:30 next day. Then we adjourn.
5:30.
I think 5:30,
5:30 is probably
6:30.
wiser.
Okay.
We'll listen to him.
An
in
hour
executive session.
would make me feel more comfortable about an hour.
And then we will, at the end of that meeting, we hopefully will understand whether we want to acknowledge or deny the 5 issues. And then we do that, and then the clock is ticking. Then we have 14 more days to figure out, how to make things right for the stuff that we acknowledge.
Right.
Yeah,
And what happens with
or
the
you
stuff.
table it, do the meeting and do it at the end of the.
Reconvene later on.
I think it could work. If we are going to acknowledge, I think it needs to be almost like that you do by a motion or some structure so that we just go through and vote rather than, garnering opinions. By that time, hopefully our opinions will be set. But just for time, I don't know, saving time.
Yes.
So it might be half an hour to 45 minutes of executive session. Then I think we do have to either deny or acknowledge, right? But then working out the cures is the 14-day part.
That's what it.
Right.
Right. So I think that could work. And
That sounds good.
I could make 5:30 and, I can come to that meeting just personally.
Does that work for other people?
Maybe.
Something you think you can,
Yes. That works for
Are
me.
you looking at me?
Yeah.
So I will be remote, but yeah, I can open the meeting at 5:30. This will be a special meeting.
That'll be a special meeting.
So we'll have to warn that.
Okay.
And then the logistical piece of that, me not being here, is gonna have to be someone will have to log in on a laptop. And then you'll have to find a place to meet or clear this room. Maybe the listeners will be kind enough to let you use their space.
Do you think, yeah, will be here early enough to help with that meeting or? Oh, no, this will be an executive. Yeah, okay. Great. I'll come ready to go on my laptop. That's easy.
Okay, so then it would be finding a space for your private and, yeah, that's fine.
Okay. All right. Let's do that. Another public comment.
Thank you. Just, first of all, I want to thank you for all the hard work you've done here in public. Not a lot of fun for you, I'm sure. It's hard work, and thank you for all the effort you put into this. I just wanted to mention that the meeting on the 22nd would be the completion of this meeting.
Yes.
And that sets the stage for what happens next. So, and just to help you organize your thinking about it, it looks to me like for item number 1 in the allegation, there are 2 questions that you have to consider and vote. Yes, we failed, and mea culpa, or no, we didn't. One is, was the agenda item sufficient? And you'll have to say, yeah, we think it was. Or you'll say no. And then you also have to say, well, were we in error by using the word proposed instead of, by using the word possible instead of proposed? That's the second paragraph in number 1. Because he's making 2 complaints there, I think. Similarly, in item 2, there are 2 complaints. One is that the agenda did not contain sufficient detail, yay or nay. And then secondarily, did not identify the matter as proposed. That's that argument about proposed versus possible. So that's 4 questions that I think you have to, after you've consulted with counsel, in order to move on to the next step of all of this. And then item 3 is a single question, I believe, that the motion to go into executive session was not adequately explained. Item 4 is the same. Was that adequately explained? And then, frankly, I have a very hard time understanding about item 5 because all of that is such a mystery to a layperson who hasn't seen any of the material. But there's surely a question there. So I would just suggest that there are maybe 7 questions that you'll have to say aye or nay to.
Yeah.
And how that works out exactly with the law, I don't really know. But you have to do that by the end of that meeting in order to comply with the law. And the law says that if you don't do that, then you are regarded as being kind of in denial of everything. And that he is free to proceed with his, however. So just trying to help with the planning, the logistics of what you've got to get done in not a lot of time.
Thank you.
Sure. It's a little tricky because the specific allegations, 5, have multiple allegations within them.
Yeah.
And then the Q's down the bottom are listed 1 through 5, with 6 as take reasonable steps. So it's a little confusing.
Right.
Did you find the same thing?
I did. Yep. But I'm hoping that council can give us counsel as well.
Yeah.
All right.
Right.
Any other questions or discussion? Well, this is, complicated. Yeah. But
So are we, well, tonight's agenda specifically said consider response. We've considered some of these responses. Are we tabling agenda item until next week, or did we just complete this adequately for the agenda's purpose?
I don't think we completed it. We were talking about gathering more information, meeting an executive session to make the decisions about whether to deny or acknowledge.
It's continuing.
It's continuing, yeah, because I think consider response to alleged open meeting law violations. We haven't fully considered yet, so it would be a continuation.
Do we need a motion to table it to a date certain, something like that? Do we need that or not?
Maybe, I think, yeah.
I think so.
Do I have a motion?
Oh, boy. Oh, I said that.
Okay.
Why do we need to do that?
That'd be,
We discussed it. Why do we need to forward it to the next?
Why don't we ask our attorney what she's.
What do you think?
I think we're just.
I mean, there's several ways you could do it. You could just, as long as it's on the agenda for the next meeting and properly warned, you should be fine. You can discuss it.
okay, that's simpler.
Great.
Make sure it's
Thank
on
you.
the agenda and properly warned.
Okay, so we'll need a revised agenda, of course.
Or next week? Is that what you mean?
Oh, okay, it needs its own
Well,
agenda.
actually,
It needs its own agenda,
like
right?
It
a
will be a
minute ago, we called it that
Special
from
meeting.
5:30 to 6:30 was going to be a
Special
special meeting.
meeting, so it needs to be
that'll
on
a
that
separately
agenda,
warned and agenda,
right?
thing.
It'll have its own little agenda, right?
Yes.
Why
So
would you not recess the meeting? I think that's much simpler.
we could recess the
You
meeting.
completed your work. I know you need another couple hours to do so. So simply recess until the time and date certain. And you're done. I don't think you even have to rewarn.
I'd be
How would
careful
people know
about
what we're
that.
doing then?
Yeah,
Well, that's a good point, yeah. You could certainly say that the continuation of a recessed meeting, and because it really is a continuation of a meeting that you couldn't get to the end of.
Well, I feel like we did get to the end of this meeting.
Oh, you haven't answered the question.
Haven't answered.
Well,
Yeah.
okay, but we considered.
them.
That's what we set out to do.
We did consider them.
Ultimately, to satify the law, you have to answer the question.
So next time we will
How much you
submit.
been paying this guy?
Huh.
How much are we paying John Carroll?
If we recess the meeting, how do you warn?
I can't imagine why we're making it this complicated.
Yeah,
I think you've done the business that was on the agenda. You've considered for almost 3 hours
Yeah.
the topic. You're gonna adjourn this meeting. We're gonna have a special meeting and take the same topic up again on 22nd at 5:30. We're gonna exit that and we're gonna have a regular meeting at 6:30.
With this,
We've already got an agenda for that.
Yeah.
So I think that's
Think we're good.
how you should proceed.
I'm waiting for a motion.
To adjourn.
That's
the one I'm waiting for.
The next motion, I think.
I think we're probably good, just with warning that special meeting. Are you waiting for a motion to,
Well, or.
Recess or something?
To table it.
or to table it? I don't know. I don't think we need it.
At the special meeting.
Excuse
We can
me?
do that.
Well, you can table it until future meeting.
Yeah, you
And
can
then-
do that.
That's easy and legal, and rather than continuing. we
Now
can
you gotta
table it.
say, in the motion, you've gotta say, we are adjourning this meeting to a date and time certain. So you have to say in the motion when you're gonna have it, and then where it's going to take place.
If we're tabling it.
Well, you adjourn the meeting to a
You're
date and
adjourning,
time.
yeah.
So,
Oh, I see.
Adjourning.
Okay.
so it could be in the adjourning, number 5. So that would be adjourn this meeting to April 22nd at 5:30 at Tracy Hall. I don't know what room should say, but
We'll find it.
let's say at Tracy Hall. We'll be here somewhere, right?
That's right.
If I may.
Go ahead. I'm sorry.
As to how, I mean, is that a continuation of this meeting? This meeting hasn't ended, it's been tabled. Like, why wouldn't you just end this meeting and start another meeting?
That's what I was hoping to do, is to table this to a future meeting and then schedule the special meeting and bring it
Like
back.
tabling is a rule, Robert's rule of procedure. There's no law that says you got to table something. You know, adjourning the meeting is, this topic is still open. We're adjourning this meeting until a date and time certain. And we're going to resume talking about this in the issue at that date and time certain. Or the select board can end the meeting, bring the meeting to a close, warn this topic again for that April 22nd special meeting. I mean, there's many ways to skin the cat, but
Either way works.
So
It sounds
either
like.
way works. So let's
Let's keep it simple.
we can adjourn this meeting,
Let's
correct?
do that.
Yes.
Yep.
Yeah.
And then warn another special
Warn
meeting.
this. again.
Okay, we'll keep it simple.
Let's do
Mary,
that.
you want to do it?
Oh, I'd love to. I move to adjourn our meeting.
Second.
Any discussion? Seeing none, I'd like to vote. Lassen,
Hey.
Clayton,
Yes.
here.
Yes.